Hi, I'm Drake Ozment. I'm a partner at Ozment Merrill. I'm a bankruptcy attorney, and we have two offices, one in West Palm Beach and a second office in Port St. Lucie, Florida. We represent clients in bankruptcy, foreclosure, and real estate throughout the state of Florida. We're here to answer some of our readers' questions and concerns about the various chapters of bankruptcy, specifically Chapter 13 today. A person is eligible to file Chapter 13 if they, one, have income, because you must have income in order to reorganize and pay your creditors some amount according to a plan that we propose for you. You cannot have secured debts, mortgage debt, car loan debts, that total a cumulative amount of over $1,090,000 roughly, or you then fall out of Chapter 13 eligibility and into Chapter 11 eligibility, which we'll talk about another time. The other limit to someone being eligible for Chapter 13 is you can't have over about $390,000 of unsecured creditors, those credit cards, medical bills, and other unsecured creditors. If you exceed that amount, again, you'll fall out of Chapter 13 eligibility and into Chapter 11 eligibility, which is another chapter of bankruptcy that we'll deal with on another interview. Payments begin in a Chapter 13 case within 30 days of the date you file your case. The court understands that you had to pay an attorney fees in order to get your case filed. Therefore, they give you 1 month before you have to make your first payment under the plan that your attorney draws up for you, which you will see prior to filing the case and know 30 days in advance how much your payment is going to be, so you'll have time to get that first payment together. In a Chapter 13 plan, all debts do not have to be paid in full. We actually take a really in-depth look at the value of your assets, your budget, and we determine how much of your unsecured creditors you actually have to repay. When it comes to your secured creditors, like mortgages and cars, we look at those one by one to determine whether you want to keep that asset or surrender it back to the creditor. And if we can eliminate any of that debt along the way, we will certainly do that. In the state of Florida, we have exemptions, and that really means things that you're entitled to keep in bankruptcy. And what we do is we apply these exemptions to the things that you own to figure out, as you go through bankruptcy, how much of those assets you'll be entitled to keep in a Chapter 7 setting, and how much you will have to pay back to your unsecured creditors in a Chapter 13 setting. It's almost a dollar-for-dollar situation. For example, if you owe $10,000 on a car, but it's worth $15,000, Florida exemption for an individual is only $1,000. You would therefore exceed your limitation on the exemptions by $4,000, and we would then pay all of your creditors a total of $4,000, and they would each get a piece of that based on the size of their claim as an unsecured creditor. So we need to look at all of your assets, apply all of the state exemptions to the things that you own to determine how much you would actually have to pay back in a Chapter 13 case. Bankruptcy laws are federal laws, and they apply to all 50 states. So a lot of the rules are very similar from state to state. However, individual states are allowed to come up with some of their own local rules, which will affect how you may put a plan together or how you may get a hearing set, and change some of the little rules from one town to the next and one state to the next. But most of the states are following the federal bankruptcy scheme. There are some states that have opted to write their own exemption rules, which there are very few of them. However, Florida is one of them. Florida has opted out of the federal exemption scheme and written their own rules with regard to what a person filing bankruptcy is entitled to keep and what the dollar amounts are as to what is protected from claims of creditors, which will lead back to how much you would have to pay your unsecured creditors in a Chapter 13 plan. And we'll connect all these dots and issues with you during our free consultation to let you know how you fit into the world of bankruptcy. Thanks everyone for taking the time to watch our video. If you have any more questions or would like to come in and talk to us in person at either office, give us a call at 561-689-6789 in West Palm Beach or 772-344-9090 in Port St. Lucie, or simply visit our website at www.ozmentmerrill.com. Thanks and have a great day.